Hello, everyone. Please introduce yourself as you come into the room, and then we'll get started. Hi, Eleanor, or perhaps it's Eleanor. Welcome. We have a few more people that I'm expecting, so we'll just hang on a few minutes for them. So we'll hang on until 12:05, and then I'll get started, and people can still join. So let's get started now, and then people can join as whenever they want, and they will be able to get a recording afterwards. So I'm Virginia Spencer. Welcome to part 1 of 4 of the Notice of Procedural Safeguards. The purpose of this webinar is to chunk the procedural safeguards into bite-sized pieces that we will then go through. This isn't a literal translation. It's actually an interpretation of the information that is in the Notice of Procedural Safeguards. So the first thing that I wanted to do is to do some housekeeping. So a disclaimer, I'm not an attorney, and this is not legal advice for your child. I'm a non-attorney representative and a special education advocate in Texas. So the difference between that is a special education attorney might not represent your child in a hearing or at mediation. And so we have the opportunity in Texas to actually apply to the hearing officer to represent clients like an attorney would, save attorney-client privilege. So we are able to do that in Texas. And then a bit of background about me. This is the least important thing, but I'm a COPA member and speaker. COPA is the Council of Parent Advocates and Attorneys, and I spoke there this year on IEPs and dispute resolution with a fellow advocate out of New York City, Tracy Smith. I'm also a member of the International Dyslexia Association. I'm a member of the National Alliance on Mental Illness and a certified presenter. I'm also an International Coaching Federation member, and I've got accredited training in ADHD coaching and parent management training, which helps parents to work with and motivate their children who are oppositional and defiant. And I'm sure nobody today has any children like that. So about me, this is what I've been told. I'm the first advocate in Texas to win a due process hearing without a lawyer. I represent families in 32 school districts. I've advised in multiple states as a parent liaison for the Foundation for Angelman Syndrome Therapeutics. That is a disability that usually results in a multiply disabled eligibility under IDEA. And I've negotiated numerous settlements with districts. So that's a bit about me. So let's get on to our focus topic today. Do you recognize this document? So I have a poll, and that poll is to see whether you've actually read your notice of procedural safeguards or not. And to be honest, this is a no judgment zone. No one's going to judge you if you left it in your inbox, or you've downloaded it and it's in your download folder, or you got it in a in-person ARD meeting and it was in paper. So it looks like someone is saying that they have read it. So I don't know if that means that the other people haven't. But in any case, what we're going to do is we're going to look at this document together. And as I stated in the beginning, it's not going to be a literal translation. You don't have to follow along. You just have to be aware of the sections that I'm covering. So the issues with the entire document are that most of the language is plucked directly from the statute. So a lot of parents don't read it because it reads like a law book or a brief or something that really is not palatable. Some of the language is very highbrow. It's not aiming at the middle reader in the population, which is usually about 6th to 8th grade. So parents they may look at it, but usually my experience has been that parents don't look at it and therefore they don't read it. So they miss out on a lot of the important rights that they have. So the learning objectives for today are to be able to explain your rights as parents, to understand the verbiage or what it means, and use it in an ARD meeting. This isn't to say you can't use it in other situations like in the community or with in a board meeting. If you're, a big advocate at going to board meetings and voicing your concerns about the school district's programs. So you can use it in any situation at all. It's not just for personal use. So what we're going to cover today is, in the Texas Notice of Procedural Safeguards, the first 3 topics are parent rights, child find, and prior written notice. And these are really important pieces within the Notice of Procedural Safeguards. Now, Texas tends to put the parent rights and scatter them among different categories. And as we go through the sessions, and there are 4 of these sessions, this is part 1, we'll look at why some of these areas that have to be covered under federal law are a little bit hidden or subsumed under other categories in the Texas Notice of Procedural Safeguards. So, parent rights, child find, and prior written notice. What do they all mean? Does this sound like fun? Are you totally pumped up to find out about these topics? I hope so. This should be, we're going to make this entertaining, even if the document's dry. So about the Notice of Procedural Safeguards, there are rules about when you get this document, and most parents get it once a year. They get it at the annual IEP meeting, the ODD meeting, but you also get it at different times of the year. So if you ask for it, you're going to get it. If you're a parent that has just requested a special education evaluation, they will give you the Notice of Procedural Safeguards. And you're probably wondering why they do that. Well, the reason that they do that is even though your child doesn't have an IEP yet, and they haven't been admitted into special education, or you haven't consented for special education, is because your child has implied rights. And so that is important to know. The rights are implied, but they can be important. So if you have a child with ADHD or ODD or a behavioral issue, and they break the student code of conduct, this is going to be very important for you, because you're going to be able to use those implied rights to get them out of a situation. And I can actually tell you a story about that. I had a child that was a 504 student in a setting, and he has severe ADHD, and he'd been influenced into accepting some edibles on campus, and the school had put him into or was proposing to put him into DAEP. So he'd be in DAEP as a freshman in high school, which was not an ideal situation. And I was able to argue that they should have done an FIE, because they knew they should have known that he needed special education for his behavior. And they actually agreed to not put him in DAEP. So there are some ways that even though your child isn't in, that can work in their favor. And that is in the Notice of Procedural Safeguards, and we'll get to that in another session. Okay, can you hear it now, Nancy? Give me a thumbs up if you can hear me again. Okay, great. I think I just clicked on the wrong button there. So they're going to give you the Notice of Procedural Safeguards when your child violates the Student Code of Conduct, because your child has special rights. They're entitled to a manifestation determination review, and that meeting is to determine if the behavior is related to the disability. So that is an important right that you have, and it happens when your child, they're looking at a change in placement. They want to put your child in a disciplinary placement or something else. And under IDEA, they can only put your child in that placement for up to 45 school days. So there are different rules under IDEA than general education, for general education students. And we'll get into that more when we get to the discipline section of the Notice of Procedural Safeguards. So we're going to talk about parents. What is a parent under IDEA? And this might seem self-explanatory, but it's not. Because a parent is whoever has the educational rights. So it may not be a biological parent. It includes them, of course. So I put that at the top. A biological parent is what you think of as a parent, somebody who has educational rights, gave birth to the child, has custody of the child, and is legally responsible for the child's welfare. Now, sometimes that isn't the parent, unfortunately. So IDEA outlines other individuals who are who meet that criteria. So a foster parent that has completed an approved training program is also a parent, and there are surrogate parents. So surrogate parents are school or court appointed, and they have to have completed a training program. Usually it's the same training program as the foster parent program. So if your rights are terminated, that is a tricky situation. I can tell you a couple of stories. I've had people call me and they've said, I need you to help me in an ARD meeting, but my wife has custody of our children and she has full educational rights. Well, in that case, there's a problem, because you could show up to an ARD meeting and the wife in this case could completely assert that you have no business being there, and she could kick you out. So that is always a problem. So one thing that I ask parents is, do you both share educational rights? And if you're in a situation where you're in a partnership and there is no contractual union, that is especially important. So sometimes the partner can assert that they're on the same page, but they can change their mind at the last minute. So I have a story about that. When I was many years ago, when I was a rookie, I was invited to an ARD meeting where mom was divorced from dad, and dad had never been. She had twins, and he'd never been there. He wasn't interested. And she said, don't worry about this ARD meeting. He's not going to show up. He never has. Well, the school was desperately trying to get dad on the phone. And I turned to mom and I said, I think I smell a rat. So what happened next was he exited the children from special education. And he can do that because they shared educational rights. So what can happen if there isn't a clear delineation of educational rights in a divorce decree or a divorce agreement? Things can get very messy in terms of advocating. So usually I refer people to a family practice lawyer, someone that looks at settlements and can amend them if need be. So custody alone isn't enough for you to say, well, I'm in charge of the educational rights. So that's something to know. And this is under the what is a parent section of the Notice of Procedural Safeguards. So foster parent as the parent. So a foster parent can be a parent under IDEA as long as they've completed that approved program. So it's 50 hours for a 2-parent household. It's usually administered by the Department of Family Protective Services within your state. So in Texas, that's called Pride Training. So they put you through this training. And additionally, in addition to that, you have to have training through the educational service centers. So I think I'm going to be answering your question, Nancy, in a second. But so that person has to be appointed to act as the parent to represent the child's educational interests in the ARD meeting. And here's something that should answer your question further. So surrogate parents. So surrogate parents may not be a parent at all. They might be a healthcare provider. They might be a friend of the family. They might be someone who works with the child. So these parents are appointed when the school just can't find the parent or the foster parent. There's no, this child is completely unaccompanied. And let's say they're in a homeless shelter. That would be a scenario where the school would have to leap into action and appoint a surrogate parent. So there are special rules for the homeless. Those rules are specific to the homeless. So the school has to go into foster care homes. They have to go into motels and hotels, and even try and locate children that are in cars, because the homeless aren't necessarily in a shelter. They could be on the street. So the way that works, and I'll give you a story in a minute, but there are specific rules for the homeless, which is the homeless children stay in the school of origin unless the parent or guardian wants to do something else. So you can't keep moving them around. And once I had, it was actually a parent call me, and a child was homeless. There was a hurricane. I can't remember which one it was. A hurricane. I think it was Ida. And the child had been displaced. And the school of origin was saying that the child couldn't graduate from that school. Now, under McKinney-Vento, the Homeless Act, there's supposed to be an advocate for each, for the child. And that advocate essentially was AWOL. They just weren't around, so we had to locate them. But long story short, that child did remain in the school of origin because that was what was best in the best interest of this child. So here's a quick break, mainly because I want to get to all of your questions. Is there any way that you think you can use this information either for yourself, with parents that you know, with community groups, in school board meetings? Is there anything that you think would be useful in that section that I just explained? Let me know in the chat box. And if nobody has any questions, we're going to move on. So Nancy has put, one of the school's obligations regarding inviting a parent who does not have decision-making authority. If they don't have decision-making authority, the school doesn't have to invite them. I would almost compare that to when your child turns 18. If you're at 18, your child has educational rights, and they don't have to invite you to the IEP meeting. So, you know, there are some things that you have to do to make sure you're invited. such as have your child sign a supported decision-making agreement, get your child into some situation where they're willing to keep working with you, and perhaps will respond to a power of attorney for education. So that's what I recommend to that. So IEP enforcement with fidelity and progress reporting. So how would you use this information for IEP enforcement? So one way that you could use this is you could assert the importance of a parent being the number one individual listed on the ARD committee or an IEP team. And often what I'm finding is just with getting through a meeting and discussing fidelity and progress reporting is the schools don't respect the parent's role in the meeting as a parent. And so this is why this is number one in the Notice of Procedural Safeguards. One of the things that's been coming up lately is the schools are dismissing ARD committee members from meetings without the parent's permission. So they have to have written permission from you, the parent, prior to a partial attendance in a meeting by an ARD committee member. And the reason for that is if the gen ed teacher leaves, which happened this morning, you don't have a duly constituted ARD committee because the person that's the gen ed rep has just left. Now, you could get a written excusal to the school and say it's okay if she provides me with a report or she answers my questions now, and those are presented in the ARD meeting. So that's a parental right. That's getting you respected in the meeting, because the respect really seems to be very hard to get in this state. So in terms of IEP enforcement, I don't think that you would use this part for enforcement with an IEP. We're definitely going to get into that in another session, but today we're covering child find and we're covering parent rights and prior written notice. So maybe in the prior written notice, I'll get to the question about IEP enforcement. So let's move on to the child find mandate. And notice I put mandate in there because the one thing that they don't put in the title of the section is that it's a mandate. It's absolutely required by the federal government. So the school district, what we're going to cover under child find mandate is the school district's responsibility to seek and evaluate children, and the extent of the school's responsibility to find children wherever they are. Now that is limited. It's limited to the catchment area for the school district, but it's everywhere within the catchment. So, and I'll get into more detail on those areas. So who does child find apply to? It applies to public schools. So ISDs are generally responsible for implementing child find. We're going to talk about methods for finding children, what they should be doing, and if children are not enrolled in public schools, where else are they supposed to go? So we're going to look at private and religious schools as well. So with the public schools, this is something interesting that you may not know. It applies to this child find mandate to find children who may be in need of special education applies to children who may have been suspended or expelled. So let's say your child has been expelled and you think the public school isn't going to find them, you should notify them. They have a responsibility to take pretty aggressive methods to find children, whether that's posting advertisements, whether it's going into private preschools, whether it's going into daycares for Part C, whether it's going into GED centers where children may have dropped out, but they're still they haven't turned 21 yet, so they're still within child find. And also those private and religious schools. So they have to contact the private and religious schools within their catchment. So homeschooled kids as well, because in Texas that is a private setting, and what really should happen, what's happened a lot with my clients is some of them have gone from homeschooled to schools, or they've gone from ISDs to homeschooled. And in those situations, the school knows when you're leaving a school, and they usually have a proportionate share meeting to talk about an individual service plan, which is, we'll get into that in a little bit here. But one thing you should know, it applies to children who are under a Section 504 plan. And that's one of the biggest things that people don't know is when your child's under 504, they're not receiving specialized instruction to meet their unique needs. So I often have parents call me and their children are struggling under a 504 plan. And generally my advice is if you believe that these accommodations are appropriate, but your child needs instruction or modification of the curriculum or modification of instruction, they're probably a child find violation. And that's a pretty shocking thing to realize for a lot of 504 parents, because often they haven't had an FIE, although I know that's changing for dyslexia now, but they often have been put on a 504 straight off the bat. So the school districts have a responsibility to evaluate children that they know have a 504 under their nose. So let's talk about what is a public school. So a public school is actually any school. The public schools are independent school districts, but public charters also fall under IDEA. Private and religious schools usually don't accept federal funding because they like to be private within their own operations. But there are some out there that receive federal funding. So I believe that they have a child find mandate. Now, how this coordinates with the independent school districts, I would have to research that for you because I'm not actually finding that information. But generally, it falls to the independent school districts to go out and find people. Now, I had someone call me from one school district about their child who was at a private school in another school district, a neighboring one. The district that's responsible in Texas for evaluating that child for special education was the other school district, not the place where the parent lives, but the place where the child goes to school. So that child find request would go to the other school district. And in Texas, we have dual enrollment, which means up to kindergarten, they can be in a private school and receive an IEP, which is an interesting proposition, and we'll get into how that works. But you have to choose at kindergarten, you have to choose between one or the other, either the private school or the enrolling in the public school. So if you place your child in a private school, direct services are provided. If the school does an individualized, they do the FIE, and they admit your child into special education. So your child gets services based on the money. There's a pot of money that the state gives the school district, and essentially the school district reports to the state the number of private school children needing services. So it's based on that head count. So the head count's very important because that determines the funding. Then those direct services are provided. They may be provided at the private school. So the ISD could coordinate with the private school, and they could be provided on the property. These services, by the way, are not FAPE. So FAPE is individualized instruction, again, to meet unique needs. But a service plan is basically what they're giving the other private school children. It's not, it doesn't meet that benchmark of being individualized for unique needs. So again, with the private placement, the school has to consult, both schools have to consult with each other on how those services are going to be provided. Is the private school going to bus the children to the public school? What does that look like? So there has to be some written affirmation from the private school if they're going to provide the services in conjunction with the public school, and it has to be completely collaborative. This is all in IDEA. And again, these services are usually what the school district has decided to provide in a given year. So sometimes it may be speech, sometimes it may be dyslexia services, but it's not necessarily the same thing from year to year. So that is very confusing for parents. And what I like to say to private school parents is, you don't have an IEP. And there's a lot of confusion over that. You only have an IEP if your child is dual enrolled before kindergarten in Texas. So some of the ways that you may use this information are to, if you are leaving the school district and you're not suing them or filing on them because they haven't provided FAPE, you just want your child in a private setting, can you tell me what the schools should be doing about that? And how can you inform the community about the responsibilities? Does anybody have a question? Oh, proportionate share funding. So I can share a document. Proportionate share funding is a formula based on the head count. I don't know exactly what the formula is for Texas. That's determined at the state level, but that's certainly something I could find out and share with you as a handout in the next session. So basically what you've learned about is what is a public school, what isn't a public school, and what the differences are in responsibility between private and public schools. So feel free to, once you get this recording, if you want to ask me any additional questions, I'd be happy to answer them. But let's move on to prior written notice. So prior written notice is the most confusing title for a document or a piece of an IEP that I've ever seen. It simply means notice before an action. And the school has to give you at least 5 days notice before a proposed action. So if they propose to initiate speech services, they have to send you a document saying, we got a meeting coming up, we're proposing to initiate speech services. Or if they're proposing to change your child from gen ed to a resource class or a more restrictive environment, they have to give you prior written notice. So they have to do it for identification of your child, evaluation, and also educational placement. Now it gets even broader than that. So prior written notice, they also have to do the reverse. So they have to tell you what they're proposing to do, but they also have to tell you what they're refusing to do. So if they're refusing to identify your child as a child with a disability, or they're refusing to do an evaluation, or they're refusing to put your child in a placement that you want. So essentially anything that you ask the school district. So let's say you ask for additional minutes in the schedule of services for more handwriting practice. They have to address it in a prior written notice document. So if you're in an ARD meeting and you say, look, I didn't mention this earlier, but based on what you're telling me, I think Joni needs another 30 minutes of handwriting instruction. And they say, well, we're not really sure, and da-da-da-da. Well, then you say, well, I want prior written notice because I need to know whether you have data that supports a refusal. And usually parents ask these questions when they have data that supports their asks, right? What you're requesting. So what should be in this prior written notice document? So there's a lot of elements to it. And first of all, there's got to be a description of the action. So let's say the action is at speech services. You requested it. You requested another 30 minutes of speech a week. And so if they're refusing it, they have to give you an explanation of why they're refusing it. And that means we're refusing it because we did an assessment. Here's the assessment. It says he's at grade level. He has standard scores of 90 on his receptive and expressive language. So they have to give the source and the basis for refusing or proposing for each action, each one. They also have to tell you that you have protections. So they refer you back to this notice of procedural safeguards. And they also have to tell you where you can get help in understanding the notice of procedural safeguards. So is that sped text? Is that someone at region 13 or region 10 or whichever region you're in Texas? Is it the parent training and information center? So those all have to be included. There's more. There's more. There has to be a description of other options. So maybe they say, well, we looked at him being in a small group and working on, pragmatic skills in a lunch bunch. We also collected data that his teachers said he sounds just fine and he knows how to talk to people. So they have to include, they can't just say no and they can't just say yes. They have to explain why, and it has to be pretty detailed. So every time you ask for a change, they have to give you prior written notice. And they also have to give you prior written notice in the event of a due process hearing. And usually that comes from the district. Once it's filed, in my experience, it's something that you should ask for in the odd meeting, where it's a non-consensus odd meeting and you're not going to be agreeing with the IEP. So where do you find it? Typically in Texas, it is found in the IEP. It depends on the district. So some districts, it's a page or a couple of paragraphs in the IEP near the end in the schedule of services. Some districts give it to you separately. Some have serious construction problems with providing it, so they will muddle everything up and you won't know. You'll have a list of all the asks, and then you'll have a muddled list of refusals and proposals, and you won't know which one correlates to the other. So usually I encourage you to send it back if you can't figure that out and say, okay, I need you to label this and give me more explanation, because I don't know which refusal goes with what proposal, or I asked for those minutes and you say you're refusing, I think. So there's often construction problems. So it's very important to know where the school district stands in relation to your advocacy. So hopefully this has unraveled some of the legalese that is in these parts of the procedural safeguards. You've made it to the end today, and this is where I can concentrate on your questions and also let you know that next time we'll be looking at parental consent, independent educational evaluations, and discipline, and that's part 2. And we'll find out that parental rights are subsumed. You'll find out that they're subsumed under discipline. So they're quite hard to find unless you've read the whole document. So prior written notice, how's it addressed for requests outside the odd meeting? Do you mean when you're talking to them in emails? Generally they have to address it regardless of whether it's in an odd meeting, or they have to call one to address it. So prior written notice for rights for children who are under Section 504. So Section 504, the prior written the rights for children. So children don't really have, I don't believe that they have prior written notice rights. They do have to notify you of a change of placement, but under 504, they just don't have the rigor and the criteria for prior written notice. So the thing to know about Section 504 is it's very nebulous, and it's up to the school to develop notice of procedural safeguards for 504. And they're not going to look like this book. So pre-odd meetings are essentially, in my opinion, so if a pre-odd meeting, which I know Austin ISD likes to do, if they don't have an odd committee assembled for that meeting, it's not an odd meeting. So you could ask for it, but they're probably going to say, well, we need to get the odd committee to look at this. So it may have to be punted to the actual odd meeting itself, but I would definitely shoot questions that they have to give you prior written notice for in the odd meeting. Rights for children who are under Section 504, you have very limited rights. You have very limited rights under 504 because you're actually not part of the committee. So if your child has an IEP or they're being evaluated for an IEP, the parent is part of the educational team that makes decisions about the child's education. So Nancy's saying they're telling parents prior written notices. Well, that means that they're essentially dragging out the process. And prior written notice is only for requests discussed in the ARD meetings. Well, they have to address all your requests. So if they don't get to them in the ARD meeting, then they're not going to be giving you a legal prior written notice document because they won't have addressed everything. So if you go in there with 20 asks and they don't get to them all, then they delayed the process. So that's a FAPE problem. You could claim that as a FAPE problem. They're not getting to everything. So 504, the child is under the ADA. Absolutely. And of course, child's under, there is a 504 FAPE. There is 504 FAPE. So 504 FAPE is the child's being provided equal access. If a child is in a hostile environment, if they're being bullied, that could be a 504 FAPE violation. So you could go to OCR and say, my child can't learn, they don't have equal access because they're being bullied and they're in a hostile environment. So FAPE is very different under 504. They don't have to provide individualized instruction, they just have to provide access. And I'll give you a story. I recently had somebody call me, and her child is receiving modifications, which really means that she needs an IEP, because then mom can talk about whether the modifications are working or not and advocate for better modifications. Because she's under 504, she doesn't have that right. She doesn't, and if you complain to OCR, they're not going to look at the accommodations that are provided. They will look at the ones that the child has that are being implemented. So there are some OCR, if you go on OCR's website and you look at 504 FAPE, there are some documents on there, and they talk about when a child cannot access their education because something is going on and it's not being addressed by the school district. So this happened to my son, even though he had an IEP. They were still violating 504 FAPE because he was being bullied and they weren't doing anything about it. So they got into trouble under 504. Gifted. So here's some advice for gifted. Here's a freebie. Oftentimes, the schools get confused over what educational rights are. Educational rights include functional, social, and emotional skills. They're in the TEKS. They're in the Texas Essential Skills, Knowledge and Skills in the curriculum. So you can go on TEA's website, look at, they actually have TEKS now for being a good citizen. They have TEKS regarding collaboration with classmates. All of those things are educational skills. So if your child is academically gifted, or they're a gifted dancer, or they're a gifted artist, they can get special education for the functional and emotional piece. So often this comes up with ADHD, it comes up with emotional disturbance where children have anxiety disorders. If your child is not handing in homework, if they're having panic attacks in the bathroom, they're not learning. And they need instruction in coping skills, and they need instruction in executive functioning compensatory strategies. So this is the argument for gifted. The argument is it's not just academic. IDEA covers social, emotional, and functional skills. So that is in an FIE, when you have a special education evaluation done, it includes all domains, and one of them is social and emotional. So if you want to reattack the eligibility issue, that is the way to attack it. You say, I actually had this issue with my daughter. She had 300 grade alerts because she wasn't handing in her homework. And I said, is this an educational skill? Does my child need to know how to do this for further education? Does she need to know how to do it for employment? Does she know how to do it for independent living? If she didn't sign her contract when she leased the house, would that be a problem if she delayed it? She, by the way, she is twice exceptional. She was in the gift. She was 3 years ahead in math. She was accepted into their gifted program, and that honestly was a journey. But this is a journey you can take, because I can tell you I have clients with IQs of 160. They also have autism. One has autism. One has emotional disturbance, and they both have IEPs. And their goals are for coping, and their goals are for getting along with people, and their goals are for self-advocacy. And those are things that twice exceptional children can get. It's all a question of educating your ARD committee on what special education is. And unfortunately, we're still at that very basic level in Texas. I don't know if Heather is still here and she can speak to her state, but it's very behind still. So in the next 2 weeks, I'm going to assemble some documents for you regarding this. But what I would like you to look at is this document. This is the Notice of Procedural Safeguards for Illinois. And the reason that I'd like you to look at it is to compare it against the Texas Notice of Procedural Safeguards. And just let me know when you come back in 2 weeks whether you think it's better, how you think that they compare. So if you haven't read your Notice of Procedural Safeguards, I'm going to ask you to do it now and just see whether you think it contains really enough information for parents to use it. And next time we're going to get into a lot of depth regarding discipline, which is a very big and scary component of your procedural safeguards, independent educational evaluations, and parental consent. So I'm going to leave this up for a couple of minutes so you can download it and compare it. If you think there are problems with it, let me know. I just want to hear your opinions because it applies to parents and you're the parents. So I hope you found this interesting and you got something out of it. And we'll get back to getting through the Notice of Procedural Safeguards. Thank you, everybody, for attending.